in the matter of Villiers and Villiers.
Yes, Mr. Capert.
May it please Lordships, I appear in this matter for the appellant with my learned friend Simon Callum. We were both instructed very shortly before the hearing before Mr. Justice Mostyn on 1st of March. And as you will know from the papers, we were remunerated by the appellant's supporters on that occasion. Today we're appearing pro bono, having read the judgment and having offered to draft the appeal notice. We've continued in this case pro bono today. My learned friends Mr. Horton and QC and Mr. Lang appear on behalf of the respondent, as they have done since I think about middle 2017, and I understand today on a continuing pro bono basis. So as a very tangential point, although the parties have spent a certain amount of money on legal representation, and mostly the wife, it might have been far worse, bearing in mind the catastrophic history of this litigation, as you referred to in your permission to appeal. I mean, Lord, I think this is the 8th High Court appearance. Well, I say there have been 8 High Court. This is the 3rd Court of Appeal appearance. And as you know, it went to the Supreme Court along the way. And I think we all agree that it's the litigation circumstances are deeply regrettable, disproportionate. And your Lordships will also probably have gathered, I'm sure you'll have gathered from our skeleton, that if this appeal is unsuccessful, the appellant will feel herself in real terms to be effectively without a remedy at all, bearing in mind the circumstances, the curious circumstances of the case and the cross-border nature of the application. Lord, it's an appeal against the order of Mr. Justice Mostyn, which was dated the 11th of March of 2021. That's at page 82 of the bundle. He dismissed the wife's claim for maintenance under section 27 of the Matrimonial Causes Act in its entirety because, as he said, at paragraph 135, she'd failed to establish what he described as a condition precedent, namely a failure by the husband to maintain the wife in the period up to the date of her application. And you will have gathered, I'm sure, and please stop me if I'm being obvious, but you'll have gathered that part of the complaint on behalf of the appellants is that is a gloss on the statute, which doesn't appear in the statute, and that's one of the core parts of the appeal today. But if I needed to refer you to the condition precedent element in his judgment, it begins at paragraph 127, that's page 124 of the bundle. And he says at paragraph 127, having set out section 27(1)(a) of the Matrimonial Causes Act 1973, which reads, as you will know, either party to a marriage may apply to a court for an order under this section on the ground that the other party to the marriage has failed to provide reasonable maintenance for the applicant. Mr. Justice Mostyn says the court has to be satisfied with this fact as a condition precedent before it can go on to make an award of maintenance. In making that factual determination, the court is required by section 27(3) to have regard to all the circumstances of the case, including the section 25(2) factors. Lord, it's
Well, the essence of his decision is probably in paragraph 28. It's the 3rd sentence?
Yes.
Where he said it must mean in the period immediately prior to the application.
Yes, Lord, precisely.
That's what his sort of legal conclusion is.
Yes, exactly. And on that basis, he says that nothing that happened thereafter is in any way relevant to jurisdiction to found the section 27 claim. In other words, if we didn't get in on jurisdiction before the date of the application, which was the 13th of January 2015, then we have no remedy. And we say that must be wrong for a number of reasons. And I'll come on to that in due course. Lord, we're seeking the overturn of his order on the 4 grounds in our notice of appeal. We're seeking a judgment to the effect that a maintenance order under Section 27 is in the present case entirely appropriate, and that in this case it should be open-ended, whether under grounds of exceptionality or otherwise. As to quantum, we recognise that on the current evidence we may be limited to a current sum of £10,000 per annum by reason of the findings that he makes in his judgment as to what the husband's current income is. Although, having said that, Lord, you will understand and you will know, having read our skeleton, that we're very unhappy with the basis on which the husband's income and capital position has been calculated. And we say the learned judge didn't sufficiently consider what was available to the husband behind the wall of his disclosure, perhaps one should say non-disclosure, which is another very significant issue in the case. And so, Lord, on that basis, we recognise that unless your lordships feel otherwise, it may be that so far as the lump sum element of our claim under Section 27(6)(c) of the Matrimonial Causes Act, unless you believe that we should and can bring one now, we accept that it may be that that element of the claim should be adjourned or no order made, because we can see that it's difficult to find a basis on which a quantum can be ascertained.
And the adjournment would be because the trustees of one of the trusts indicated that they had, whilst it was at the time they wrote the letter, it was in their view, it was very unlikely that either the husband or the wife would benefit from that trust. There were a number of matters that they needed to consider before actually determining how to exercise their discretion.
Lord, precisely, and you're thinking now of the husband's father's will trust, which was something that came into this equation fairly late in the day. You will have perhaps gathered from the chronology how that happened, in the sense that it only became relevant when the respondent's father's second wife died, she being a remainder man under his will of, I think, 1999, but his death in 2005 left her a tenant in possession of their matrimonial home in London. She died in 2019, and that triggered the remainder provisions of the will. And you will have gathered from what we've said that there are a number of beneficiaries under that will, one of whom is the husband himself, one of whom is the father's disabled daughter, if I can use that expression, who had been cared for by her mother, namely stepmother, namely Mr. Villiers' senior's second wife, and in addition, named beneficiaries, although the will isn't in the bundle for some reason, and I apologise. Named beneficiaries include the wife, qua wife, and the daughter, the party's daughter, Clarissa, who you will be aware of, obviously, and who's now 25 or 26. But they're named beneficiaries. And it's right to say that they've been discussing this trust and this will with the trustees, Paynick's Beach. For some reason...
Are they the trustees or the solicitors for the trustees?
I think they're the trustees.
Are they?
Yes. I think, as well as solicitors, I think they...
Right.
She's been discussing it with a Mr. Bacon, James Bacon from Paynick's Beach. And I'm not sure the identity of the trustees are, but certainly Paynick's Beach seem to have accepted the authority to deal with and administer the will. When we first raised it, the moment Mr. Callum and I came into the case, we raised it with Paynick's Beach because it didn't look as though much had been done at that stage. And we were told in the week before trial that the estate was in administration and there was nothing to be done. We then got the letter from the trustees, which your lordship referred to, dated the 2nd of March, in other words, the mid-trial, that said we can't be sure, but it's highly unlikely that you will benefit from it. But of course that hasn't satisfied my lay client, because she obviously unfairly needs to know what the real position is. And so she's been to see the trustees, and she's, as it were, pleaded her case, both in writing and orally, and she's waiting for an outcome of that meeting. And of course, that may make a huge difference, because whilst she would never, and we would never on her behalf, seek to interfere with reasonable provision for the party's daughter, who's I think now about 40 years old, but lives, I think I'm right in saying, in a care home for all or most of the time. But whilst we wouldn't for a second want to interfere with reasonable provision for her, it is entirely possible, on the information we've got, that there would be surplus funds available for other beneficiaries of the will. And in the context of this case, where a husband says that he effectively hasn't got anything and his trustees won't give him anything, that could be extremely important. And that was the basis of the way we presented the case to Mr. Justice Mostyn. The week after we saw the papers, because at that stage it looked as though it was common ground that the property in Notting Hill was worth about £10 million, give or take. I'm not sure exactly what it sold for. It's that sort of thing. And it's relatively substantial sums in the context of this case. Consistent with, we would say, and with all due respect, the husband's non-engagement in this matter, he has simply suggested that he's got very little prospect of receiving anything under the will. But bearing in mind the history of the case, and you will have read that in the judgment of Mr. Justice Mostyn, the husband's attitude to this case, we can't take anything for granted. And so that's a legitimate, we say, avenue of investigation that's currently proceeding.
Just to, for my own purposes, to be clear, you're not pressing for a rehearing, is that right?
No, not. In a sense, we're in the hands of the court, in that what we say in the first place is that this order, the judgment and the order cannot stand. And therefore, we would ask you to, I was just explaining what we were going to ask the court to do.
Yes.
We don't want an immediate rehearing, in the sense that we don't know what the outcome of the Payne-Hicks Beach situation is. And we also don't want a rehearing on the basis of the evidence that the husband's presented to this court so far. That's another discrete complaint that we make about this, and it's confirmed and endorsed and upheld by Mr. Justice Mostyn. His disclosure in this case has been woeful, even by the standards of woeful disclosure cases. And in fact, it's right to say that Mr. Justice Mostyn said it was the worst case of its kind that he'd ever come across, which one might have thought is saying something from him. But 6.5 years of no bank statements at all. When we went into the hearing, despite any number of orders for disclosure from a series of judges, I think including encouragement from this court, when the matter came up on appeal on the jurisdiction point. But the fact is that although Mr. Justice Mostyn found, or declared that he found, that there was nothing more to know about the husband's finances, we don't accept that. And we think that we're entitled to bank statements over a 6.5-year period, or 7 years now, and entitled to 1 or 2 other documents of disclosure, including his passport, which, as you will have read from the judgment, he said he couldn't find. Unfortunately, it looks as though the matter can't be concluded today because of the ongoing uncertainties. Firstly, as to the capital value of the father's trust, and secondly, as to the ongoing income position of the husband, which he hasn't
and this is
disclosed.
getting way ahead, because obviously there are a number of matters that have to be addressed.
Yes, of course.
In the court. But your submission is that if the appeal is successful, that you're not asking for an immediate rehearing, but you are asking for an order of £10,000 and the adjournment of the lump sum.
My lord, yes.
Right.
Whether you call it an adjournment or whether there's just simply no order is a matter of construction. So we made an application under Section 27, and within Section 27 there is the power to order a lump sum. So it's not, as it were, a Section 23 and 4 lump sum application. It's an order for maintenance.
No, I see that. And the 10,000 that you would be inviting us to make is without limit of time.
Yes, yes, which is another of our grounds of appeal.
Yes. Thank you. Well, that's helpful. Thank you.
Lord, the other thing that we would ask, if the court's with us on the principle of something of that kind, is a disclosure order against the husband. Firstly, that he comply with the previous orders made by this and these courts, including that of Deborah Eaton QC.
It would be unusual for a Court of Appeal to make an order like that, wouldn't it?
I think it is unusual, my Lord, and that's why I approach it with a certain amount of diffidence. It may be that, and we're hoping that you will, having heard the case and having decided that it's the right order to make, that you make this order. So far, there's no court in this country that's had the effect of persuading the husband to comply.
Right. Okay.
There was a judgment summons listed to be heard at the same time as the hearing last year, but that was adjourned for various reasons which we're not appealing. So that we've got no enforcement application on foot at the moment. Indeed, Mrs. Villiers has absolutely no funds whatever to do anything with, and as I indicated earlier on, we think that, quite frankly, this case has occupied enough of this court's time already.
And presumably those considerations also apply to why there's been no application for contempt. The wholesale disregard of court orders is usually met fairly early on by an application for contempt. But as I understand it, there's been no such applications here.
No, Your Lordship's absolutely right, and certainly, in as much as Mr. Callum and I are involved, we thought it was better to concentrate our efforts on the hearing that was listed and ready to be heard. We complained, obviously, during the hearing, and we cross-examined on the point. And since then, we've not, and I think we explained in our skeleton, rather than taking that sort of step now, we thought that the appeal was more important, because without the appeal, we've got no cause of action anyway. So that's why. But, my Lord, yes, in terms of the merit, we say there is irresistible merit in enforcement or committal applications in respect of that disclosure. And without straying into it any more than is necessary, but you'll have seen from Justice Mostyn's order that even he found that the excuses, the reasons for the non-disclosure were, he described them as absurd. One was that the husband didn't want to go to his bank for risk of giving the bank staff COVID, and that way he couldn't get bank statements. And as far as the passport was concerned, on one occasion he'd said he didn't have one. On another occasion he said that he'd lost it. He told us it was in the house somewhere. And when he was invited during the hearing in cross-examination to look for it in the house, the hearing being remote, he indicated that he might, but hasn't. So this all goes to whether or not we need further disclosure orders. We say, with respect, we would if the court's with us. And I appreciate it's an unusual application. It's not something this court normally deals with. But we'd extend it, if you were with us, to the bank statements and the passport, and secondly, ongoing disclosure of any payment made to him by either sets of trustees, or any other communication between him and those trustees relating to payment or potential payment of any monies to him under any of the relevant trusts. And thirdly, disclosure of any other income, ongoing income, by way of employment or self-employment.
None of what you've just asked for is in your appellant's notice. I'm just looking at the appellant's notice in tab 1 at page 11 of the bundle. And the orders that you asked the court to make there are maintenance at a rate of not less than £10,000 per annum, adjourned lump sum costs.
Lord, yes. That's absolutely right.
So it's not in your appellant's notice and it's not in your skeleton argument.
No.
Is there any form of application notice?
Lord, there's not an application notice formally before this court, no. And to that extent,
and did you tell Mr. Horton that you were going to be making this new oral application not foreshadowed in writing?
I'm not sure. Possibly not.
Right.
Possibly not. Lord, it would flow from your view of the merits of this appeal and whether or not you thought it was an appropriate incidental order to make in the circumstances of the case. It's certainly the case that he knows that we've been on about this certainly since we were involved a long time before that, obviously.
So you're asking the court to make an unusual order, which on its face appears redundant given all the orders that have been made before, without any written application, without having forewarned your opponent. Is that really a great way to proceed?
Well, to describe like that, it clearly isn't, no. I can only apologise if if it appears an incompetent way of doing it. As I say, it really only would flow from your views of the main substance of our appeal and what the right remediative answer is to the situation we find ourselves in. I mean, you're absolutely right that if you don't make disclosure orders, that's by no means the end of the matter at all. It was merely a hope that it might persuade the husband that he ought to listen to this court, if not previous courts, giving disclosure of what we say are important matters. And it all consistent with his general duty of disclosure that runs throughout the course of this case and continues to today. But
So that set out your ultimate goal.
Lord, that's our very limited ultimate goal today in the circumstances that we find. We're not asking the court to make a speculative order beyond the £10,000 because that would per annum, because that would involve a finding of fact as to the exact income which we've been unable to prove in the circumstances.
Okay.
But in those circumstances, can you explain to me what the point is of your complaint of non-disclosure? I mean, the judge fully accepted the merit of your client's position that there had been egregious non-disclosure. And you say he shouldn't have done. I understand why you say that, but what I don't understand is what the point of considering the question is when you're not seeking to challenge the judge's evaluation of the appropriate amount that should be ordered.
Well, we're not asking this court to challenge or to look at a revised quantum because we are lacking evidence, which is not the appellant's fault. It's as a direct result of what you described, my lord, as an egregious breach of disclosure. And I suppose the merit is that this court might be inclined to, as it were, take a firm grip of this case and do its best within the confines of what's appropriate and proper to ensure that it stops meandering around up the highways and byways and is put into good shape with proper disclosure. We're not asking for anything new, or this has all been before the court, before Justice Mostyn before.
I'm sorry, I'm clearly missing the point. If you were, let me give you a hypothetical, and we assume, of course, that you succeed on the jurisdictional aspect. So we assume that the court concludes that there's power to make an order in your client's favour. Now, if you were saying £10,000 is not the correct figure, we should have 20,000, 30,000, whatever figure it might be, then one could understand the point of the ground of appeal that says the judge ought not to have ordered only £10,000 because he ought to have reached a higher figure having regard to the non-disclosure. But once you accept the £10,000 figure, what's the point of considering whether there's been the consequences of the non-disclosure? Where does it go?
Well, the point, Lord, is sadly but inevitably a further application is going to be required, would be required in respect of the lump sum if investigations as to the trust position are satisfactorily concluded, but also in respect of the maintenance itself. There would have to be another maintenance periodical payments hearing on the basis of proper evidence when proper evidence was disclosed. And what we're saying, we're not trying to overreach ourselves. We're trying to say, surely £10,000 on the judge's own findings must be reasonable. The principle of an ongoing order must be reasonable. That's what we seek, pending our ability to show that there's very much more. And our ability to do that, which was something that we were keen on establishing back in March of last year, was completely hampered by the non-disclosure point. So we're saying that it's egregious non-disclosure, but it goes to the merit of the case. It goes to the heart of the quantum and value of the case to this wife appellant.
It seems to be relevant on what you've just said to a hypothetical future application.
It is, my lord, and we have already accepted, I think, that there will be a future application, but we accept reluctantly, most reluctantly, that in the circumstances you can't find an extra 20 or 30, whatever it is, £1,000 per annum on the basis of the evidence that you've got before you. What you've got before you is a case that's been struck out on what we say are impermissible technical grounds. But what you don't have before you is an application, as it were, a de novo first instance application on the merits of what the figure should be. And that is because, fairly and squarely, we say the husband's failed to give proper disclosure. Had he given proper disclosure, and had we taken the view that his position was reasonable and sustainable, then firstly we would have been asking for more than in the first place, and secondly our position in this court today might be slightly different. But we've moderated it, as it were, to try and be reasonable, and to ask this court to do something that it can, we say, have no objection in doing, because it's not overreaching itself on the basis of the evidence. We're very unhappy with the evidence. I entirely take your lordship's point, and as it were, I'm not seeking to hide behind it, but it's our attempt to be reasonable in terms of what we're asking for today.
I think well, if I understood it correctly, really, I should leave it for my lord to speak. But I think all my Lord Justice Arnold is saying is that we may not need to go into your ground 4 in great detail, given what you are now seeking from this court.
Well, my lord, I take that point.
So I think that. So should we get to the substance of your appeal?
Yes, Lord, certainly, I'm obliged. Lord, just a word about the bundles. Your lordship had rather bigger bundles than you would have expected under the terms of practice direction. I don't know if that's caused any unhappiness on the
I haven't noticed. I don't know whether anybody else had noticed, so no.
Well, I'm very much obliged.
We are actually just missing 2 pages. Well, I seem to be missing 2 pages. I'll actually ask my colleagues whether they are. From the husband's second Form E, we're missing pages 11 and 12 of that Form E, which would appear between 198 and 199. We jump from page 10 to 13. So if at some point we could be provided with pages 11 and 12, that would be helpful. Is yours the same?
Yes, it is.
So, so if we can... I think you've set out in your skeleton, or maybe in the judgment, I can't remember which, what the husband says on those pages about his trust interests, which I think is broadly similar to what he set out at page 184, but that's where it would be, and we just happen not to have that.
Lord, very well, and neither
Thank
do
you.
we, so we'll see what we can do as quickly as possible.
Right.
Not sure if Learned Friend's got a copy in his...
Well, at some stage we'll be provided with it.
Lord, certainly.
Thank you.
Lord, and you will probably also have noticed that that this isn't an appeal from the Supreme Court, and
I don't think we need to get into that at the moment.
no. But all right. Well, I'll leave the question of bundles. As I was afraid you might be a little unhappy about the contents of some of them. And there are 1 or 2 orders that you might have expected in there which aren't there, but nevertheless, you've got a lot of accounts which you probably have been able to skim over.
Yes.
In the supplemental bundle.
Yes.
Disastrous bundles was yesterday's case.
Ah.
We think that generally speaking, they're all right.
Oh, well, we're very, very relieved in that case.
It's all relative.
All relative. What order you go in? Lord, I was going to, by way of summary of what
Sorry, while I'm asking for additional documents, I think it might be helpful if we were provided with a copy of the interim order made by Mr. Justice Parker.
Yes, well, that's.
And we don't have that.
I agree, you don't.
And I think that would be helpful if we could be provided with that as well.
We'll certainly do that, Lord. You don't have the Court of Appeals order, your Lordship.
I don't think we need that,
order.
do we?
Not necessarily. You also don't have Deborah Eaton QC's order, except in a very redacted form. But since a lot of that goes to the question of disclosure, it may be that you feel it's not necessary anyway. But the order of Mr. Justice Parker, which was a substantive pay maintenance order, is clearly important, and we'll get that to you as soon as possible.
Thank you. Yes.
Lord, what I was going to do was simply look at the facts and circumstances that makes this case rather unusual in fact and law, and why this court's being asked to make an ongoing maintenance order in respect of a marriage contracted in England, but destined at some stage to be ended in Scotland. And I'm sure your Lordship has picked up all the nuances and implications of that. As I understand it, the husband's petition in Scotland is still sisted. So there is no petition, there is no decree in Scotland. So the parties are not divorced.
Can you explain to us why it's still sisted? I appreciate you may not have full knowledge, but to the best of your understanding.
I can tell you to the best of my understanding, my Lord, is that it was, there was some prospect of it proceeding last year or the year before, but amongst other suggestions made by the husband was that this wife was a bigamist, and that in some way affected the validity of her claim, her response to the suit in Scotland. The sheriff referred that to the police, who carried out an inquiry and found that there was nothing in it at all. And the sheriff, of his own volition, assisted the case, and that's what we understood this time last year at the first hearing in front of Justice Mostyn. And we've heard nothing since then. As far as Mrs. Villiers is concerned, she's heard nothing, and her understanding and that of our instructing solicitors is that that is still the case. So, for what it's worth, there is no decree of divorce insofar as it is relevant to any of the English applications for maintenance, or indeed applications under the 1985 Scotland, the Family Law Scotland Act, as well, which provides for very restricted maintenance from the date of the decree. So, curiously, it looks as though, well, I mean, there is no order. There's no order for financial provision, and there's no order on the suit in Scotland. Lord, secondly, we were going to look very briefly at Section 27 itself, including a very short foray into the history, very much shorter than that provided by the trial judge, including the scope of available remedies, but importantly, the basis on which it's been brought into being. And I don't know if your Lordships have had a chance to read the Law Commission reports that we've included in the bundles of authorities in this case, but they're significant, we say, in an interpretation of Section 27. And likewise, the speech of Lord Justice Thorpe in Macfarlane, which we've set out in full, relevant passages anyway, in our skeleton, and which is something I very much want to draw your Lordship's attention to. But in terms of interpretation of Section 27, what it was for, and how therefore it should be interpreted, and whether therefore the learned trial judge's enthusiasm for importing old principles of common law duty to maintain into an interpretation of this, what we would describe as the modern law, we say it's significant, and it's significant in that it shows that his approach to this is with respect, wrong and unsustainable. And Lord Justice Thorpe describes the purpose and the purport of Section 27 and indeed Section 22 with admirable clarity in Macfarlane. I was going to refer your Lordships to that. My fourth point was the duty of full disclosure, which maybe now is somewhat redundant.
I got the second point with Section 27.
Yes.
And foray into history, as you described it.
Yeah, more the third point was the way it's been interpreted by the court.
Oh, okay. Sorry. Thank you.
Yes, I'm sorry. I skipped one. I beg your pardon. Your Lordship's quite right. The way it has been interpreted by the courts thus far, and we've been able to find two authorities of some relevance, H and H and M, where in the High Court, both of them, the correct interpretation by implication or explicitly is set out. And it's our case, of course, that it's a here and now situation, that to go back to the date of the application is artificial, illogical, and unfair. And we say that H&H and M, Mr. Justice Newton in one case and His Honour Judge Booth in another case, show clearly that their approach to it was on the basis of what is the here and now at the date of the hearing, and that's important.
That's the third point.
That's
So
the
the
third
fourth point.
The fourth point is the duty of full disclosure, and why it's so material within the present proceedings. But I wouldn't want to labour that in light of the indication of Lord Justice Arnold.
Yes.
And in a way, it is so trite, and indeed, my Lord Justice Moylan has been the author of a number of important judgments on the question, including Moha, which we cite in our bundle, and the implications and consequences of non-disclosure. But it's why we're hamstrung even on this appeal, and why we haven't made progress. And of course, we would have loved to have taken enforcement proceedings and had them effective, so that we can put this canard to bed if it is a canard. But that's always the inherent problem of non-disclosure. And when there's evidence, and I won't go into this in any great detail, understand the indication I've had, but when one has evidence, primary evidence in the case of trips to Russia, trips to Dubai, or Abu Dhabi, I think, working for an oil company, that kind of thing, lots of social media tweets that we've all been able to look at, that give a prima facie indication of economic activity on behalf of a husband who says effectively he's so poor he's having to sleep on a park bench in a park in Edinburgh, bearing in mind the lack of trust between the parties, and then coupled, as it were, retrospectively with the learned trial judge's findings as to egregious non-disclosure. It is extremely frustrating. So, my Lord, then point 5 is the judgment of Mostyn J, why we say it's wrong and unprincipled and can't stand. And 5b is, as it were, in particular, that he's wrong on 1, the threshold condition, the condition precedent test. Secondly, and these are set out as headings in our notice of appeal, as you know, failure to maintain and how you quantify that, the failure. Thirdly, duration and potential duration of orders under Section 27, and the judge's insistence in his judgment to import the old case law on common law duty and comity into the discretionary exercise, and going off on a further extension of Section 25 by talking about exceptionality and the circumstances in which exceptionality of a long duration order are to be enforced or applied. And my fourth point was failure to draw adverse inferences, which we have discussed to a certain extent. And, my Lord, the last point was the outcome sought, which we've discussed.
That's 6.
That's 6, yes.
Thank you. Yes?
Which we've discussed already. So, my Lord, I hope Lordships accept that force majeure, the scope of this appeal is limited to that which we set out in our notice of appeal and our skeleton argument. We would like further progress in the case, but we acknowledge that there's only so much this court can do, or perhaps would want to do, in the circumstances of this case. So, my Lord, I don't know the extent to which it would be helpful to go into any background of the case. We accept that on the whole the factual background is set out by Mr. Justice Mostyn, paragraph 57.
Well, are there any particular features of the background circumstances or facts that you want to draw to our attention?
My Lord, I draw attention to the first of those would be the fact that this husband has never paid a penny to his wife, despite the ongoing substantive orders. And it's he who's been pursuing the jurisdiction point throughout the courts of England and up to the Supreme Court. That's been his approach to all of this. He's not wanted to address this on merit until he lost in the Supreme Court. But he's been aided by his trustees, whom he says are not in any position or have any mind to assist him, describing him as financially improvident and irresponsible. But they were prepared to help him with the Supreme Court case, and they advanced him a sum of £49,000 to take his jurisdiction point to the Supreme Court. So we draw attention to that. We draw attention to the fact that this wife went into the marriage as a relatively wealthy woman and has put her entire life savings into the marriage and the matrimonial home, and that since 2012, when the parties separated, and specifically since 2014, when the party's daughter, of her own volition, obtained a non-molestation injunction against her father, it's been the mother who's been looking after the daughter in somewhat traumatic circumstances. I won't go into it, but it has been said on a number of occasions that the daughter has been quite upset by all of this, as one can perhaps imagine. But so during the time, since separation effectively, she's had a very difficult time of it. She's also, a point that the judge made findings about and drew attention to, she also, when she left, had reason to suppose that there was some equity in the matrimonial home. You haven't seen the particulars of the property in the selling brochure prepared by, I think it was Savills, before she left the matrimonial home, but it certainly, as the judge found, shows a beautiful house, beautifully decorated, and in tip-top condition. And the photographs which emerged when the wife went back a year later to find, as the judge put it, the house completely trashed, with furniture everywhere, a lot of furniture missing, apparently sold, the garden a tumbleweed mess, and effectively the house in such condition that the agents gave notice to the husband who was handling it, because he stayed on living there after the wife left, that they couldn't market the house. It was nothing like the brochure. And on that basis, the loss in value of the party's equity in the property has to be placed firmly and squarely at his door. And that since that time, the wife's financial position has been dire. She's a part-time gardener and has got at least one client whose garden she looks after. But as you can imagine, it's been a strenuous and difficult time for her. And she's been supported by friends for the last 10 years or so, who had hoped that the order of Mrs. Justice Parker would enable them to be repaid the monies that they've been lending her over the past 10 years. And deeply disappointed that that's not the case. And so when we went to trial in March of last year, the total specific debt to her friends and supporters, to include some legal fees, was £717,000. That's a sum that remains outstanding, and that's a sum that reflects her standard of living between 2012 and 2021. And it includes rent on a property, which is where she's been living, had been living. The owner of the property has slightly lost faith now by reason of the real possibility that he's not going to get his money back. And he's asked her to leave, and she has left. And that property, I understand, is on the market. She's now, as it were, squatting with friends. But it's set out in the judgment, and I don't want to overdo it or over-egg the pudding, but the circumstances of her life, financially in particular, since that time, have been pretty dire. And to have faced the opposition she's faced in the courts, and in respect of sorting out her overall situation, it's been very, very difficult indeed. won't say more because it would perhaps over highlight the emotional rather than the sheer physically practical. But we're all familiar with cases of one party or another who are left effectively destitute and hence extremely worried, and this is such a case. Your Lordships, I'm sure, are aware of the reasons why the wife's petition in this country was stayed and then dismissed. And your Lordships will be aware that under Section 27 of the MFPA 1984, there's no Part 3 claim available to her in this country in the event that there's a decree and an order in Scotland. So she finds herself, by reason of comity, by reason of the various statutes that provide for this form of inter-UK cross-border applications, that she's in a very, very difficult situation. She can't petition in this country. The petitions in Scotland is not within her discretion or power to progress it. It's been assisted by reason of circumstances outside her control, affected with the husband's behaviour. There's no financial provision offered by that, and your Lordships will obviously be aware as well of Section 9 of the 1985 Family Law Scotland Act, that effectively, and this is an interesting curiosity in this case, in a way, effectively limits her maintenance claim to one of 3 years following the decree of divorce, at best, unless there are exceptional circumstances. And it's the wife's advice, it's the wife's understanding that she's not going to get an ongoing maintenance order. I think there's nothing between the lawyers about that, but it's difficult to think that she will get a maintenance order. And also capital claims in Scotland are dealt with very differently from those in England. In England, there's all the panoply of relief available, particularly in respect of lump sums. In Scotland, the lump sum is restricted to an payment out for an interest in property, matrimonial property. There's a separation of matrimonial assets, but the court expressly does not take into account inherited assets, previously acquired assets, and assets that have emerged or appeared through a third party. So her position, despite the comity provisions that were thought to be sensible before the 1985 Scotland Act, do in fact have a curiously depressing effect on a wife's claim when she's in a situation like this. And certain fact that if the claim was in this country, this country's powers would be extended to lump sums based on general equitable principles. It may be that she's entitled to a pension order, but that's a pension sharing order, but that's problematical at the moment because it would seem that the value of the pension has been reduced to virtually nothing, or so that's the husband's case anyway. But a piece of land that was worth £5,000 at one stage and had an offer on it of 1.2 million apparently, is now said by him to be worth £7,000 because he says the planning, the zoning has disappeared, lapsed, and so there's no merit or equity in that. So she's in a situation where, quite apart from the fact that the husband says he can't afford anything, her right of remedy in the Scottish courts, as and when, is not of much practical use to her. And it's in those circumstances, we say, that the Section 27 application comes into its own. It's been described as being rare, which it certainly is. One of the cases, I think it was His Honour Judge Booth, noted that it had been described as moribund, but that, said His Honour Judge Booth, is certainly not the case, because here's a very good example of where it provides proper remedy. And that's where we are in this case. It's an unusual set of circumstances But the essence of our submission is that it's on the statute book. It was expressly put onto the statute book in 1973. It was amended in 1978, effectively taking out all element of fault or mens rea out of the failure to maintain. And what once upon a time been a willful failure to maintain, in circumstances where there were matrimonial offences which would affect the outcome of such a case, it's now morphed, if you like, from 1978 into an English 1973 Act relief that's available to anybody who fits the criteria. And so, and expressly, it has incorporated into it Section 25 factors, as you will have seen or will see from the decision of two decisions that I've already referred to, and indeed the helpful judgment of Lord Justice Thorpe in Macfarlane. So the whole landscape has changed. And so we say, frankly, the old cases, the matrimonial fault cases, are of very little value to this court. We've swept away an awful lot of old law and old thinking about it. This is a case that's contained within the general parameters of the Matrimonial Causes Act to achieve justice between husband and wife, or in a matrimonial context. And there's no realistic and there's no proper fetter to be put on the exercise of the discretion under Section 25, which applies to the Section 27 application. And it's, as I think I indicated a moment ago, it's again particularly curious, but that as a result of the Section 27 of the 1984 Act, the Part 3 remedy is not available to this wife, even in the event that the husband finally gets on and obtains a decree of divorce. And I'm sure the thinking behind that is that there would never surely be any need to make extra provision for an unprovided for wife in particular, following a foreign divorce, which is where Part 3 comes into its own. Other jurisdictions where a wife, let us say, quite commonly would not be provided for at all and wouldn't have proper provision. So in those circumstances, Part 3 application is quite common. But in this case, as a result of the 1984 Act, the remedy is not available to a wife. So she can't claim under Part 3, which again imports with it the Section 25 factors. So she's effectively left with Section 27. And we say there's nothing wrong with Section 27. We say it's a perfectly self-contained remedy based on merits. And this wife effectively fits firmly within it and is entitled to a remedy. Lord, I've got a short section here on the litigation history. I don't know whether that's of interest or importance to your lordships, or whether you've picked that up in your reading already.
I think we've probably picked that up already in our reading.
Well, I'm very much...
I mean, it's extraordinary that the case took the time it did to reach the Supreme Court, but it took the time it did. And I don't think it helps going through looking at why that happened.
No, I obviously wouldn't seek to impute any criticism or any observations about the length of time.
It just did take a long time.
It took a year to get to the Supreme Court. But having said that, it took over a year to get a judgment from Mrs. Justice Parker. I mean, for what it's worth. And again, there's no criticism at all. But the application was first made in January 2015. The hearing was in July 2015. There was a judgment on the 23rd of March and an order on the 8th of July. So
2016.
2016.
Yeah. So there was the application was heard in July 2015.
Yes.
and the judgment was March 2016,
Yes,
and a subsequent hearing and order in July 2016.
Lord, yes. Yes. So there was the first year and a bit gone. And then the husband applied for leave to appeal to this court in October. It was dismissed by Lady Justice Hallett. He tried again, and that didn't come on until the 29th of June 2017. So 8 months later, when Lady Justice Black allowed the application. 11 months after that, the appeal came on before Lord Justice Moylan, Lord Justice Richards and Lady Justice King, where the wife was successful, the husband was unsuccessful, and the court thereby accepted the wife's right to apply under Section 27. It being said that, it being argued all the way through, at that stage by my learned friend who'd come into the case, learned friends I should say, but this court accepted that there was jurisdiction to hear the wife's claim, and that it shouldn't be stayed, and the appeal was dismissed. 7 months later, the Supreme Court gave leave to appeal on payment of the £30,000, and that hearing took place 1 year later, the 19th and 20th of December. And the judgment in that case was given on the 1st of July 2020, when the husband's appeal again was dismissed. And I'm sure your lordships have read that decision, but Lord Sales was in no doubt that in terms of jurisdiction, this applicant had a choice of remedy, and she was perfectly entitled to take whichever one suited her best, and if she thought she would do better under Section 27, she was quite entitled to do so, and that there shouldn't be a stay. It's also right to point out that there was stiff opposition from Lord Wilson to that proposition, supported by Lady Hale. But that's why it lurched on through the teens, and on the 1st of March, so quite quick in the scheme of this case, quite quickly afterwards, the application was finally heard by Mr. Justice Mostyn. Lord, whilst I'm on it, as far as jurisdiction was concerned, we both submitted opening skeletons. Ours was at B400, Learned Friends at B423 for the record.
B400 and B423.
Lord, yes.
Thank you.
And we addressed what we thought were the issues at the time. It's probably worth pointing out in passing that Learned Friend didn't take a point at that stage that the condition precedent applied to an application under Section 27. And I think it's fair to say, I'll be corrected if I'm wrong, but I think it's right to say that nobody has taken the condition precedent point up until Mr. Justice Mostyn mentioned it to us on the first day of the remote trial, which began on the 1st of March. Because, and I don't criticise him for it for one bit, but by as it were, a supplemental skeleton or a new skeleton, Learned Friend introduced or adopted the concept of condition precedent for the first time. We, of course, argued against it throughout the hearing, and we were unsuccessful, clearly. But that was the first time that we'd heard any idea, or we had any suspicion that anybody was going to suggest that there was a condition precedent to making a Section 27 application. And it's curious to us that that point was firstly not raised, but secondly wasn't considered by any of the justices who've heard this case. Clearly, Mrs. Justice Parker didn't think much of it, or didn't think of it at all. This court, on the appeal, clearly didn't consider it an objection to dismissing the appeal. The Supreme Court didn't consider it a relevant factor. And it was only with the introduction of Mr. Justice Mostyn that this concept of condition precedent, namely that the cause of action had to be in existence at the date of the application, which is, I think, a charitable way to put his condition precedent, entered into this case.
But the question wasn't before any of the previous courts. I mean, you mentioned the Supreme Court, for example. They were considering purely jurisdiction as between England and Scotland. They weren't at all concerned with the substantive conditions that had to be satisfied, were they?
No, my Lord, I absolutely right, and I'm not saying that they should have done. It's just an observation that nobody commented on it and nobody took the point up. Perhaps I'm on stronger ground to go back to Mr. Justice Parker, to whom the interim maintenance application was made, Section 27 application was made, and she did not, as did Mr. Justice Mostyn 5 years later, take a point of her own volition that she couldn't hear this unless the wife had proved a condition precedent. And that's the point.
Well, is that necessarily correct? I mean, we might have to look at what she said in her judgment, but presumably she proceeded on the basis of the two applications which were before her. It might be worth having a quick look at those. So they're in the core bundle at tabs 8 and 9. So the originating application is the one at tab 8. And we can see it's an application under Section 27 of the Act. I, the wife, a spouse of the husband, hereinafter called the respondent, say that the respondent has failed to provide reasonable maintenance for myself and has failed to make a proper contribution towards maintenance for the child of the family. And that is dated the 13th of January 2015. So
Yes.
the basis of the application brought by your client was that the respondent, quote, has failed to provide reasonable notice.
Yes.
So that was a complaint about his failure in the period prior to the 13th of January 2015.
Yes, Lord, that's absolutely must be correct.
And then if we look at the interim application notice, that's the next tab, and it doesn't tell you anything about the basis for the application. It simply refers to the attached statement, which we find at tab 10. And we find there your client's statement of the 14th of January 2015, and the gravamen of the complaint is at paragraph 3. Since I left the matrimonial home, and we see from paragraph 2 that that was on the 22nd of August 2012, the husband has refused to pay me any maintenance despite my requests for financial assistance.
Yes.
So that is a complaint of failure in the period 22nd of August 2012 through to 14th January 2015. Yes?
Yes.
So that was what was before Mrs. Justice Parker.
Lord, that is correct, yes. And absolutely.
And so Mrs. Justice Parker will have considered whether there was a reasonable basis for that allegation.
Yes.
I think
And she thought there was. And
Yes.
because she thought there was a reasonable basis for that allegation, she made the order she did.
Yes.
Mrs. Justice Parker was not concerned with whether there might be a basis for making an order due to a change of circumstances in 2019/20, was she?
No, your Lordship's right. I stand corrected as far as the application itself in front of Mrs. Justice Parker.
Well, but I'm sure we're going to come to it. Actually, subsection 5 of section 27 deals with an interim application, and that sets out that the court can make an interim application make an interim order when the court cannot yet determine what order to make on the application if the court considers that the applicant is in immediate need of financial provision. So it's a specific provision in section 27 which deals with the circumstances in which the court can make an interim order, and that's what Mrs. Justice Parker would have been exercising.
Yes. Well, it's not, as it were, a principal point. It was an observation that nobody had taken this point before, but you're obviously right about that. And it applies obviously also to, for example, Section 22 applications, general interim maintenance, even when, for example, there's a challenge to the jurisdiction, and the courts have got the power under the Matrimonial Causes Act to make orders, even in circumstances where ultimately it may be that there is no jurisdiction to make a substantive ongoing order. And that was the rationale of changing the basis of maintenance applications brought in by the 73 Act. And we saw that in the progression of the authorities relating, for example, to maintenance pending suit or litigation funding, the A&A orders and the G&G orders. And the courts decided or held that they had enough power under the terms of the new Section 22 to 27 to make orders providing maintenance for an applicant who satisfied the conditions of Section 25(2). So, if I take a bad point about Mrs. Justice Parker, I'm rightly corrected by Lord Justice Arnold, and as it were, I wasn't seeking to criticise her for having got it wrong. I was just observing that this point arose from the judge's bench on the morning of the substantive hearing. And of course that, to anticipate something that I'll come to quite soon, that gives a huge illogicality to these applications, because if it was thought that there's likely to be such a situation arising, any sensible wife would, as a matter of practice, reissue her application the day before the hearing to make sure that that isn't something that occurs, which is curious, and we say in our skeleton illogical and unprincipled and just wrong. But if that is the consequence of Mr. Justice Mostyn's order, it's something which this court might like to take into account when deciding whether or not that's the right approach to take. Of course, every applicant could seek to reissue or amend her, if it's her application, shortly before trial, just in case a situation like this arises, which would be a sort of belt and braces approach brought on by this interpretation. But that is hardly satisfactory. And it's much less satisfactory in a situation like this, where on any view there's been massive non-disclosure, and a wife can't possibly know what the husband's financial position is. The wife can't possibly know whether or not the trustees, at the time she issues the application, are going to be difficult about making provision for their beneficiary. It would be monstrously unfair if the wife would be, as it is in this case, if the wife is to be penalised by finding subsequently on an investigation of the evidence 6 years later that the trustees had said in 2014 that they weren't going to give any more money to this improvident beneficiary with whom the wife had been living for the duration of the marriage, well, up until quite recently before that. If she was to discover that as a subsequent fact-finding hearing, the trial judge takes into account the fact that the trustees didn't in fact make any payment to the husband between 2014 and 2021, and uses that as evidence to confirm the suggestion that they weren't going to give him anything in 2014 as well. And it becomes almost circular. But how is she expected to know whether or not she runs a risk of the condition precedent being found in those circumstances? A, no disclosure, and B, the previous track record that is contentious, to put it neutrally.
Can I just ask, the expression condition precedent in this case, did that come from the judge?
Yes.
Because it's wholly incorrect as a description. I mean, we understand what you mean by condition precedent in this case, and the judge even has a section of his judgment heading, condition precedent. We're not talking about a condition precedent. We're talking about whether or not you look at evidence, circumstances, post the application, before the hearing. That's really what this is about. A condition precedent is where somebody has to either do something or fulfill a particular category before they can go on and then claim something or other else. That's not this case. This case is all about the point. Your point is the wife ought to be able to look at have the judge look at the circumstances after the application, but before the hearing. Mr. Horton says no, it should only be the information available up to the time of the application being made. That's the point. That's not a condition precedent. I mean, I know that's what the judge called it, but I think it might have led to error, possibly on the part of the judge, to consider this as a condition precedent at all. What we're looking at is simply what you can and can't take into account on the hearing of an application under Section 27.
Well, my Lord, it's completely true to say that the expression came entirely from the judge. We had heard nothing of it before the morning of the trial, first morning of the trial, when he said that in his view there was a condition precedent. The language is entirely his. And I suppose, well, we understood it to mean, at its most charitable interpretation, that we had to establish as a condition precedent that the husband had failed to maintain the wife up until that period, as at the date of the application, that he had failed to establish, he'd failed to maintain, not willful anymore, but that we had to prove that he had not maintained us. And the judge, having said it's a condition precedent, went on to say a number of other things, as you'd have read, that, for example, a reasonable failure to maintain would escape him liability, for example. And that was part of his gloss on what all of this meant. But yeah, we certainly were surprised by it. We didn't agree with it. We argued against it, and we don't think it's sound in law.
Well, and as my Lord said, it is inapt because, as subsection 3 says, and again, we're probably jumping ahead, the court is directed to look at all the circumstances of the case when deciding both whether the respondent has failed to provide reasonable maintenance and what order, if any, to make. So the court has to conclude whether or not there has been a failure to provide reasonable maintenance. That's part of the statutory provision. But that's, I think it's inapt to describe that in the way the judge describes it as a condition precedent. It's just part of the statutory structure. And he's limited his assessment, consideration of the evidence to the period, for the purposes of determining 3A, in other words, whether the respondent has failed to provide reasonable maintenance, to the period to the date of the application.
Well,
That's what he's done.
yes,
But you're coming to that when you're dealing with Section 27.
yes, because
So he distinguishes between what the court does under 3A and what the court does under 3B.
yes, he says there's a gateway you have to get through.
Yes.
By establishing something. He then goes on to qualify it in again difficult and unhappy circumstances by suggesting that the trial judge must pick the relevant period, presumably at the time of the hearing, for the during which time the so-called condition precedent must apply.
Right. But is that all you wanted to say on background facts and circumstances? Have we
Lord,
got to the
I
end
think
of that?
so. Your Lordships have clearly had a chance to read the judgment and plot the facts. Are you completely au fait with the values of the trusts?
Why don't you deal with that?
The learned judge deals with it at paragraph 66. But if I can give you a broad outline, it's all supported by a lot of evidence in the supplementary bundle, including the accounts. But effectively, the husband's grandmother died in...
Can we give them names? Because sometimes they seem to be called different things.
Lady Mary Berry.
Right.
Of the Londonderry estate in Northern Ireland. left a will that set up 4 trust funds called respectively the Discretionary Fund, the Lady Rose Fund, that's the husband's aunt, the Grandchildren's Fund, and the Lady Elizabeth Fund. Dealing with those in turn, the Discretionary Fund has subsequently been named or has come to be known as the Mount Stewart Discretionary Fund. And the trustees make it clear that the husband has no expectation of benefit from that fund, even though he's a potential beneficiary, because in their discretion they're intending to use it for the upkeep of Mount Stewart. There are grumbles about the merits of that decision, but that's not something that this court needs to concern it with. So for the purposes of today, we can assume that the trustees are not planning on distributing any of the Mount Stewart Fund to the husband.
Do we know how much is in it?
Well, there was about £3 million placed into each of these trusts in 2009.
Yes.
In the Mount Stewart Fund at the moment, there seems to be 2.77 million left.
Thank you.
And there are accounts, but I'll deal with it in this way if it's convenient to the court. The Lady Rose Fund is not one that we need to be concerned with, because that's the husband's aunt, and the beneficiaries of that are her issue. So the £3 million to that side of the family is not of any interest to us. There's then a Grandchildren's Fund, again about £3 million, give or take. The husband had a 1/3 life interest with power to appoint capital. The highly significant aspect of this fund is that both other beneficiaries have received their capital payout. So both of them have received £1 million, give or take, in full and final settlement of their interest in that fund. And the accounts of that fund are in the supplementary bundle, and I can give you your lordship's page numbers if you want. But you can see the relative value of the trust running through the accounts that we've been supplied with in 2017 to 2020. Of the husband's 1/3, 324,000 was paid out to Clarissa's education fund to pay for her fees at Cheltenham and other upbringing expenses. That was, I think, shortly before or at about the time of the separation. The current total in that fund is said to be £484,000, according to the 2020 accounts. But actually, it may be that it's 435,000. Well, that's what the judge took, because the husband's £49,000 I referred to earlier to get him to the Supreme Court isn't accounted in that figure. So the judge thought you should take 49,000 off the 484 because he didn't think the husband was going to pay it back. And so it is said that that fund is now worth £435,000. And it's right to say that if you look at the accounts of the 2020 fund, you will see that it's effectively Charles Villiers' fund. And nobody else is interested in that trust anymore. The professional...
Where does it... He has a life interest.
He has a life interest with power to appoint capital.
Yes. And what happens if the capital isn't appointed?
I think the trustees have the power to pay out interest and pay
who does it go to in the event that... Who does it go to if it's not exhausted during his lifetime?
I don't think there's a remainder on that one. May I take instructions?
Let us know later. Right.
Well, I'll let you know later. But that's a fund that's being depleted on a pretty regular basis by the administration costs, which are quite hefty. certainly a figure of £40,000 per annum is something that we've found along the way in the accounts. So
Is the answer to my Lord's question, I'm looking at paragraph 68, subparagraph 1 of the judgment, is the answer that it's the daughter?
The daughter's certainly a beneficiary of some of them.
Because it says, subject
yes,
to such
yes.
appointment, the daughter is the capital beneficiary of the husband's share.
Yes, well,
So that seems to suggest that if there's no appointment of capital, then she receives what's left.
Yes, well, your lordship's entirely right. Yes, I'm obliged. But I was making the point that the capital value of this fund is decreasing fairly alarmingly.
It's a slightly self-fulfilling prophecy that will be exhausted one way or another.
Yes, it's a point we made at the hearing. It's a point we make to this court. It's a point we make to the husband. It's a point the husband should be making to his trustees. But there seems to be, if this is all as it appears, this fund is, as you say, self-fulfilling in its diminution towards the point of extinction, which is unfortunate. One would have thought that somewhere along the line the parties themselves, or even if it's only the husband, but query, would he want to take it, knowing that the wife has a capital claim in the wings? That's all part of the malafides that exist in this case and the suspicions swirling around. But it's certainly a fact that it's a trust fund with his name on it that you would have thought that he could call for, bearing in mind the history of the trust and what the other two beneficiaries have done. There's no other person with any interest in it.
Right, so that's, and then we have D, the Lady Elizabeth Fund.
It's Lady Elizabeth Fund, which the husband has a 50% interest with his sister. Lady Elizabeth died, and they both share the interest, the capital value and interest. Capital value to the husband's £872,000. In the accounts, all these accounts are in the supplemental bundle. My reference for that is 354.
Yes.
And that's one of the two trusts from which the husband's deriving an income. Lord, you probably picked it up already, but there's an accountant's letter, supplemental bundle, page B460, that sets out from the accountant of what benefits have been received under these trusts, what income has been received under the trusts. There seems to have been a hiatus because it seems that the accountants were advised that for a period after the husband's bankruptcy, which was between November 2013 and November 2014, he wasn't entitled to receive interest under the trust for a further 4 years. I must confess I don't know how that could have happened, and I don't know why it happened. But what I understand is that is what happened. And it's only now, over the last 2 years, that a much fuller amount of interest being received by him under the terms of those trusts.
And is this set out in paragraph 62 of the judgment? Are those the figures that you say derive from the accountant's letter at SB 460?
Did you say 82?
Did I?
No, I'm asking.
I meant 82.
Oh, I looked up 62. But
sorry, I meant 82.
Yeah, exactly, my lord, yes. And that comes from the accountant's letter, which is at SB A3.
Right, okay, thank you.
A354. Sorry, B460, beg pardon. Yes.
While we're on this, could you just help me? Because when you look at the figures for 2019-20, the total before tax is just over £30,000. In paragraph 142, and then it's net income after tax of 27.7 roughly. In paragraph 142, he refers to now receiving about £28,000 a year in net income from the two funds. Am I correct in understanding is that that's his rounding up of the last figure we see in paragraph 82?
That's how we understood him, Lord, yes.
Thank you.
And you'll see if you're looking at paragraph 82 at the same time that the payments from the Lady Elizabeth Fund were non-existent for the first 3 years of that calculation. And only at 2018-19 did they amount to anything. And then this last year they're relatively significant. It seems extraordinary that that's a clerical or a legal error, but that's what we're told.
Sorry, say that again?
I said it seems extraordinary that what we're told is that was an error, legal or clerical or otherwise.
Sorry, which was an error?
The fact that the husband wasn't receiving his
Oh, okay.
full entitlement under
Yes.
the Lady Elizabeth Fund.
Yeah, sorry, yes.
And we're told that there's no recourse, and we're told that there's no proposal to pay out money that should have been paid out in 16, 17 and 18,
Right.
which again seems surprising.
So those are the trusts under the Lady Mary Berry
Yes,
settlement.
yes. Lord, may I make one other point about those, which is relevant to all of this. Despite being asked to ask the trustees what the maximum they would pay to him would be, the husband submitted in his replies to questionnaire dated 24th of February 21 that he's never actually made a request, or not since 2014 anyway. And the judges who were dealing with the interlocutory directions hearings were asking him to ask the trustees what the most they would provide to him would be under those trusts. But he accepts and admits in his reply to questionnaire that he hasn't made such a request. He says that they won't do it. He says, look at the correspondence. And it's right to say that the correspondence, which is liberally splattered through the first part of the supplemental bundle, is depressing from the point of view of a beneficiary who's hoping for some assistance from the trust. Whether there's a complication as to the question really is, and what was put to him is that he's simply not asking them because he doesn't want them to say yes, and they've got a duty. If it's a professional trustee who's one of the members of the trust board, who has a professional duty to act in accordance with trust law at all times, and if she were asked whether or not the trust would consider making a payment to him at his request, it may be that they'd have some difficulty in saying no, bearing in mind that it's his fund, and all that's happening to it is that it's just quietly running into the sand for whatever reason. So the only answer the husband's given in his replies to the questionnaire is that you know perfectly well what the answer to that is because you keep asking the trustees, and the trustees keep saying no. But it's a curious fact that there's been no formal request by the husband for assistance from the trustees of either of those two capital funds. Reference is page 369 if there's any issue about it.
Thank you. So,
Well, that's the position under the maternal trusts.
yes,
Under the paternal trust, we've largely dealt with it, but you'll have seen a reference is B438, the letter from Payne Hicks Beach.
yes.
Extremely unlikely was the expression used.
And we have no accounts in respect of that trust? We do.
We not in the bundle. We have accounts showing the value of it's a company that owns the house.
Yes.
And it was in the last one I looked at the value was in at about 280,000, which is I think what the house cost back in the 1960s or 50s. But what we do know is that it's been sold for approximately 10 million, and we do know that the trustees are holding on to that money for the time being in circumstances I described
Yes.
a little while ago. And I'm not sure that we can help you very much more on that. I mean, the reason that it looked to us as though it might be a hopeful avenue for the wife to pursue in this case is because she's an actual beneficiary. She's a name.
Sorry to interrupt you, but can I be clear as to what your position is on the father's estate? Because the judge's finding at 62 was that the husband has no realistic prospect of benefit from the father's estate in the foreseeable future. You're not challenging that, are you?
Lord, my lay client is challenging that in the sense that she's making representations to the trustees. The judge has got that from the letter written by the trustees, page B438.
Which where he sets it out, doesn't he? Does he set out the relevant parts in paragraph 61, or do we need to look at the letter itself?
No, but as a matter of interpretation, this is a letter that arrived in mid-trial, and of course we.
You were going to give just give us the reference for the letter.
It's supplemental bundle B438.
Thank you.
Relevant passages. They regard that eventuality, namely benefit to Mr. or Mrs. Villiers, as extremely unlikely. This is for a variety of reasons, including the testator's wishes and other factors relevant to the exercise of their discretion. Among those, the real possibility that significant financial support may be required for the long-term needs of another member of the Villiers family, which we understand to mean Catherine, I think she's called.
So the judge had before him that letter, which was an extremely up-to-date statement of the trustee's position.
Yes.
So in what way did he err in paragraph 62 in saying it was plain from that letter that the husband had no realistic prospect of benefit in the foreseeable future?
Well, my Lord, I can't say that he did in that respect, but what I can say is that that was received in the middle of the trial, obviously came as a disappointment, and it's obviously something that we haven't, I say we collectively, our lay client, would want to pursue to see what what that actually meant. Looking at the letter at face value, if she was to be put off, she would be put off by that.
But you seem to be criticising the judge, and I'm still grappling to understand what your criticism is.
I'm not criticising him for that on that aspect of it.
Right. So you accept that he was correct to take into account what the letter said, and correct to draw the conclusion he did at 62.
I can't criticise that, and Lord, I don't think we have. I tell the court that further negotiations and discussions are ongoing, and I respectfully advise a little caution before irrevocable decisions are made on the basis of that letter, because that was the first response that the trustees gave to the request for information from our side, and what one could say, all right, fine, we'll forget about all of that, but our lay client is not minded to do that. Apart from anything else, her daughter is also a beneficiary, and she would want to explore it, and she's been invited to explore it with the trustees. She's had a long meeting with the trustees and has made representations to them in writing and I think at the meeting. And I think from our perspective, that pessimistic outcome is not assured, it's not guaranteed.
So are you inviting this court to make a finding that there is a realistic prospect that the trustees will change their position at some point in the future? And if so, upon what basis?
I can't do that.
Right.
I can't do that, Lord, because this is the evidence. The evidence since the trial has been, as I've told you. I'm not criticising the judge for saying what he said on the basis of that letter, but what I am saying is that if the lay client stroke beneficiary of this will has not given up hope of receiving some benefit from the will and has discussed it actively with the trustees, and I would be very disappointed if an order was made on the basis of the judge's finding that this was a hopeless cul-de-sac.
Thank you. Yes.
Could you just give me the reference to the 10 million? Don't worry. If it's not
Might
to
have
hand,
to ask
don't worry about it. It's just that paragraph 61, before it gets to the letter, says that it's not known what the estate currently comprises, although it's believed to be of some substance, as it includes a valuable house in West London. Well, it doesn't, because that's been sold. So it's a question of what the money is, and the letter doesn't appear to deal with that, or at least certainly not in the passage cited by the judge. So if at some point, just what the reference is to the...
My Lord, certainly it may be that at that particular moment the property hadn't been sold, but that there was an offer available on it, and the figure of 9 to 10 million is one that sticks in my mind, and it came from somewhere, and I'm sure there's more substance than just my say so.
I should think it did stick in your mind because it's the only example in this case of some real money.
Exactly. Sadly, that's the case.
A lot of expenditure, no real money.
Yes, Lord,
Yeah.
Exactly. And for those of us on this side, and indeed my own friend's side, who say this is madness, we agree. But I ask rhetorically, what is a wife supposed to do in these circumstances?
Right. So, anything else on background facts and circumstances?
No, my Lord, you've got the non-disclosure points and the travelling points.
And you refer in your skeleton to a number of orders that were made requiring specific disclosure.
Yes.
And that disclosure was not given.
Yes. Lord Parker J, 8th of July 2016.
I think on reflection it would be helpful to have those orders.
Yes.
In other words, the orders, the interim maintenance order, which is that order,
Yes.
but the orders requiring specific disclosure.
Lord, I'm obliged. I've got them on my system conveniently together, and I'll make sure that we send them to the court, perhaps at lunchtime. But there were orders from Parker J, Roberts J. There were indications from the Court of Appeal. Moore J made a very specific order, and Deborah Eaton QC made a particularly specific order at the PTR in the run-up to this hearing. And I hardly need to tell your lordship why it matters and what the point of all of this is. But we've referred in our skeleton argument to Lord Wilson in Gohill, and that effectively without this information a court is disabled from discharging its duty, and that of any order is to that extent flawed, that it's impossible to advise a client what a reasonable expectation might be, or to formulate open or without prejudice offers to settle a case. It might even expose lawyers to a negligence claim if it later transpires that there were indeed undisclosed assets. It leaves a deep sense of unease that one party is getting away with his or her non-disclosure and contempt of court effectively. It renders toothless the injunctions within Form E. I say injunctions, but the extortions in Forms E that a defaulting party would be in contempt of court and might go to prison. And effectively, we say it's a blatant and unpunished contempt of court. My Lord's already made reference to that, and we agree. As far as the authorities, again, I just mention them as we go past. We've included 3 in our bundle. Moa, which was Lordship's decision. NG and SG was in fact Moylan Friend's case in the bundle, and Crowther was a decision that we put in as being a very recent decision that looked at the latest authorities and the rationale behind them and the process that a court must undertake in the event that there is non-disclosure of this kind, and the drawing of inferences. Lord, we complained in our skeleton that paragraph 103 and hence 104 of the learned judge's judgment was an unfair description of the wife's attitude to this. I'm not sure if my learned friend is going to accept this in due course, but It may be that he doesn't. But in terms of whether or not this wife accepted the state of affairs, that effectively the inference or the finding that there was nothing left, and the judge's conclusion that there was nothing left to find, it's never been our position. Never been our position. We're not saying that there's a fund of £10 million in a bank in Abu Dhabi. We can't do that. But what we can do is say that there hasn't been proper disclosure, and the small sums that are involved in this case, and Lord point out already, it's not at the moment, it's by no means a big money case. And hence, for her to come to this court and say, well, please at least give me £10,000 a year from your trust interests, is a reasonable and modest approach to this. But it makes a huge difference whether or not there has been activity around the Gulf. There has been activity within a bank, 6 years now of Barclays bank accounts, not disclosed at all. Sums of money in the account. He told us when he disclosed the account for the first time on the Wednesday before the trial on the Monday, that he had a bank account with Barclays. He'd had it since 2016, and he had £6,000 in it. He couldn't produce the bank statements because he didn't want to give the bank COVID. And anyway, they came out of a glossy Roneo machine, and he wasn't able to go and get them. And that was the excuse for not giving it. And all of that does go to whether or not that evidence can be accepted by us, and we don't accept it. It's risible. It's risible, and I'm only sorry that we haven't been able to deal with enforcement of that more effectively.
So the short point is that you say there's no basis for 104. He simply doesn't know because you don't know.
Precisely.
Nobody knows.
Precisely. Precisely.
And in a case where the contempt wasn't purged, it doubly so that the judge shouldn't have reached any conclusion about what he knew or didn't know, because he didn't know.
Well, precisely. And if there's any element of amor propria observed on the bench, that I say you can't attribute that abandonment of responsibility to his position, and it's only because we never thought that, we never said that, and that would be a wholly wrong response to take to this degree of egregious non-disclosure. Your Lordship's got the point. So, Lords, we've as far as the appeal on Section 27 is concerned, our objections are firstly that the judge is wrong to require a condition precedent test. Secondly, he's wrong to take a relevant period, a period of 2 years prior to the date of application. Thirdly, he's wrong that an order should not or could not extend beyond a divorce in a foreign country. Fourthly, he's wrong to say that only exceptional circumstances would justify such an order extending the duration. Fifthly, he's wrong to say that the common law duty to maintain is to be imported into the discretion under Section 27. Sixthly, he's wrong to say that comity in some way is to be imported into the discretion. And seventhly, if you like, that his approach to the Supreme Court's decision in this case is unsatisfactory, but it certainly comes through very clearly that he took the view that the views of Lords Wilson and Lady Hale were correct. He does say that there's no point in me fighting old battles by proxy, and he goes on to say that plainly the risk of duplicative and therefore irreconcilable judgments is now significant, and it's really very clear, and no disrespect to either judge, but in his description of Lord Wilson's CV and Lord Wilson's eminence, that in some way should entitle or enable this judge to prefer the view of Lord Wilson when he is bound by a 3-2 Supreme Court majority.
It never worked the other way when Lord Wilson used to pronounce on commercial matters when he was in the majority and very eminent commercial judges were in the minority. So I think that ought to be a level playing field.
Well, wouldn't dissuade your lordship from that view.
Could you just repeat your fourth, because you went quite quickly?
Sorry.
That's right. Wrong to say...
Wrong to say that exceptional circumstances were required to extend an order beyond foreign divorce. The essence of much of what we say, my lords, and I hope it's clear from our skeleton, because we do try to deal with this in the skeleton, and I don't know quite how much more I can say on the overall principle, but Section 27 was a section that evolved through the jurisprudence of the Law Commission and Parliament, and by the time Section 27 arrived, or was amended, I should say, the important date is 1978, is when it effectively ruled out matrimonial fault, and the willful element of neglect to maintain was removed. That this court, I've said this before, I appreciate, but this court has an open discretion, subject really only to the Section 25 criteria, as to whether or not to make orders for maintenance, which has a wide compass and includes lump sum and other provision for either party, because either party's got the right to bring an application under Section 27, or indeed any of the other sections in that part of the Act. And it doesn't need any reference to 1952 cases or 1925 authorities or any of the earlier decisions that were all based with a different approach to the statute and provision for families, and also the existence at the time of the matrimonial offence. And we'll look at it perhaps in a moment, but when Learned Friend, for example, has produced an authority yesterday, which, interestingly enough, is the first authority that we've seen that would in any way support Mr. Justice Mostyn's submission about condition precedent. The judge in his judgment says there isn't any authority for this, and we say no, well there isn't, and we looked around and found two that are in our bundle. Learned Friends come up with one, but of course it's very interesting and significant. We say that it's a 1953 case in the days when matrimonial fault was very much de rigueur and would govern a wife's entitlement to maintenance. So there's been a shift, a complete shift, and I scarcely need to address this bench on the progression of the Matrimonial Causes Act and the remedies available in matrimonial
frankly,
cases.
bizarre to go back to 1975 to decide how to exercise the court's powers under sections 23 or 24.
The raison d'etre for 1953. Lord, I quite agree. I quite agree, and there's a body of jurisprudence that's built up, of which your lordship has played a part, that tells practitioners and tells us how to interpret section 25 and the sections 22 to 27. That's why we were particularly keen on the judgment of Lord Justice Thorpe, who set it all out quite carefully.
This is your second topic, which is section 27.
Lord, yes.
Are you going to start by taking us to the section itself?
I was going to do that just now.
Okay, sorry. Can you just help me? Irreconcilable judgments. It's a complete tangent, really. But what was he talking about? What was the judge talking about?
I suppose he was talking about the possibility that a Scottish court would make an order that was appropriate under Scottish law, but it would be irreconcilable with an English judgment.
But what, a maintenance order?
I suppose. Or either.
Right. Not a capital, because the capital order wouldn't.
Well, that's
because
quite...
because there are no marital assets for distribution. other
Well,
than
no-
possibly the pension, which is said to be worth nothing.
Pensions, exactly. That would be in Scotland. Yes.
Yes, that's what I'm saying. I'm trying to work out.
Quite. And
So it's on the assumption that there might be a maintenance order made in Scotland, which would be reconcilable with the maintenance order here. Was that what he was talking about?
I think he was. I assume he was more thinking that there might be a substantive order for maintenance in this country, which the Scots in the divorce would never have made, and wouldn't like, and that in some way, the provision for ongoing maintenance is not something that's appropriate to a divorce in Scotland.
Well, if one looks at paragraph 5 of the judgment, where this point is mentioned, he seems to be focusing on the fact that there's parallel claims for capital sums in both jurisdictions.
Yes.
So there's a claim for a capital sum of £1 million in Scotland, plus interest, and a lump sum by way of capitalised maintenance in this jurisdiction.
Yes.
Well, that's what he's talking about, isn't it?
Well, my lord, it may well be.
But the capital sum in Scotland is not maintenance, is it?
No.
Because yeah.
No, and it's a slightly problematical aspect of this case that the assumption that the claim for £1 million in Scotland is likely to be a good claim is not a given, and the reason for making the claim nothing to do with us.
Okay. Anyway, we're going off at a right. Thank you.
Yeah.
Yeah.
I mean, she's being advised by very eminent Scottish lawyers.
Yes. Yes.
And your lordships have got the benefit of what they've told us. Lord, so section 27. It's at the beginning of our authorities bundle.
Yes.
It's at page 36 of the authorities bundle. Either party to the marriage may apply to the court for an order under this section on the ground that the other party to the marriage, in this section referred to as the respondent, A, has failed to provide reasonable maintenance for the applicant, or B, for the child of the family.
So presumably you would accept, on the basis of that statutory language, you can't make an application on the grounds that the respondent will, not has, will fail to provide reasonable maintenance 6 years in the future.
Well, it's an interesting question, my lord, as when one comes to the date of the disposition, whether or not, for example...
But that's not my question.
No, I know.
My question is, can you apply on the ground, can you literally put in your application notice, I'm applying, not because I say there is any past failure to provide reasonable maintenance, but I claim that in 6 years' time there's going to be a future failure to provide reasonable maintenance. Is that a valid basis of application, having regard to the statutory wording?
Well, Lord, I was going to offer you an example that wasn't so extreme. I was going to offer you an example of, say, a month or 2 months. In other words, if the payer says, well, I'm not going to pay you with effect from next month, so get used to it, and that's it, would the applicant be entitled to bring a claim at that stage to be ready and have a case in court for the 2-month period that she'll get maintenance but will not thereafter? And that was part of our submission, that the disposing judge really should look at this on the basis, decide it and dispose of the case on the basis of the here and now.
So your submission is that it's a valid ground of application to say no past failure to give reasonable maintenance, but I claim that in 6 years' time there's going to be a failure to give reasonable maintenance. That's a valid ground of application, you say?
Well, Lord, on those facts, I'm sure the application would be dismissed. I'm sure the application
So you accept it's not a valid ground?
Well, I'm not sure that it would be, no, because we hadn't got that far. except that if the application is made, and by the time it comes for hearing, there's been a failure, then we say yes, that becomes a valid ground, because that not the specific the application for the court. The application for the court is being heard at a time when the payer has failed to provide reasonable maintenance for the applicant.
So you can acquire the cause of action during the pendency of the proceedings.
Yes. Yes. I mean, of course, normally these things are coterminous. And so a number of the examples that we've seen are all a little bit on their facts. I mean, almost all applications for maintenance under Section 27 are going to be because the payer has stopped paying. I'm not going to pay you any more money. You know, go to the races. At which point the application is made, and that's what will normally happen. So the fact situation that we've got in this present case that Mr. Justice Mostyn was dealing with is very unusual, particularly where the wife doesn't know whether there's been a failure on his terms. She knows there hasn't been any maintenance.
I was going to say the thing that was missing was the reasonable point, because it's a fact that there was no maintenance.
Yes.
So my Lord's point as to the past tense of has failed is met, save that was there a failure to provide reasonable maintenance. It all turns on how the court approaches reasonable.
Yes.
Does it look just at the material pre the application, point I made before, or does it look at all the circumstances?
Yes.
That's the issue between you.
My Lord, yes, I accept that. and I say that although one reads this and Lord Justice Arnold's supposition or question to me is, does that mean that you may apply because he might fail rather than because he has failed, whether or not that does what happened in this case, namely negates the application from ab initio, or whether or not if an application is made and somebody can rightly say, well, hang on, I haven't failed yet, but I'm just about to, and does that mean that the applying party has to go back to basics and start all over again?
Well, you could take it further. If the respondent writes a letter saying, I'm going to stop paying next month, and what's more, I'm taking all my resources and disappearing, would the applicant be entitled to apply for an injunction, even though at that date the respondent was in fact paying reasonable maintenance on the basis of a future threat to do something which would subvert the entitlement to receive financial provision under Section 27?
Yes, and to which the answer is plainly yes. If one
so you say that a party is entitled to apply in the face of a threat to do something. You don't have to wait for that threat to be carried out in order. I'm not sure that I would describe it as a cause of action. It's more an entitlement to claim under Section 27 for an order.
Absolutely, and that's one of the issues in the case that my own friend has produced, as to whether or not it's a cause of action, whether or not the wife has a cause of action against her husband, or as you're suggesting, that that he or she have got the right to claim, which is a different thing, and one survives death of the paying party and one doesn't. Two authorities in the bundle that my own friend is going to refer to. And we say absolutely, this is not a cause of action. This is a right to apply for maintenance under the terms of the 73 Act. But in the family courts, family court would be perfectly prepared to accede to an application for a preventative injunction to prevent dissipation of funds, or an imminent attempt to deprive the potential applicant of a remedy by a Section 37 application, and it's done quite frequently.
But that's on a conventional basis of seeking any injunction.
Yes.
For any injunction, it's sufficient to show that there's a threat to do an unlawful act.
Lord, I agree.
But that's the court exercising its general powers as a court of equity,
Yes.
not exercising the power under Section 73.
Well, the court's got a power under Section 37 to prevent the dissipation of assets.
We're talking there about Section 37 of the Senior Courts Act.
No, of the Matrimonial Causes Act.
Right. But again, it's a separate power.
It's a specific separate power, but it's within the matrimonial causes jurisdiction, and it's one which is designed to preserve. It takes its origin forth from the Civil Courts Act, from the Senior Courts Act, and from the injunction jurisprudence going back to all the moreover injunctions.
All right, but I'm grateful for the elucidation, but I'm still puzzled because you're relying upon the court's power to grant an injunction, which you say derives from Section 37 of the Financial Causes Act, and that's to prevent dissipation of assets. Fine. But if the court has the power to do it on that basis, how does that inform the interpretation of Section 73? Sorry, Section 27, I do apologize.
27. Well, I'm not saying that it does necessarily. I'm saying that it's a coincidental, a parallel remedy available to an applicant who's entitled to ensure that the fund from which he or normally she wants to preserve or achieve the lump sum is retained.
I think it might be because Section 37(2) stipulates that you can make an application under that section where proceedings for financial relief, which includes Section 27, are brought.
Yes.
So you have to have brought your application under Section 27 and you make it under that heading. And what we're debating is whether there is actually no jurisdiction to bring an application under Section 27 until there has been default. And you gave the example of somebody threatening that they would do something but haven't yet done it. In those circumstances, there has not been a failure to provide reasonable maintenance because they're still paying reasonable maintenance.
Well, it presents a problem for the applicant, and what normally happens is on the matrimonial injunction situation is that you invariably have to undertake to file proceedings as part of the process.
Anyway, that was a slight. So you've taken us to 27(1).
27(1) A and B. Jurisdiction isn't an issue. Subsection 3. Where an application under this section is made on the ground mentioned in 1A above, deciding whether the respondent has failed to provide reasonable maintenance for the applicant, and what order to make under this section in favour of the applicant, the court shall have regard to all the circumstances of the case, including the matters referred to in section 25(2). And we say that's significant because to refer to the matters in section 25(2), those are very much forward-looking matters. They are things that they're the here and now. They're past, present, and future, really, because they can include conduct, and they can include dissipation, and they can include other forms of asset distribution. They can include contribution, as well as needs, financial resources, and so forth. So when we describe in the skeleton the here and now of section 25, that's what we mean. And the court has to do that, and indeed in the two authorities of H&H and M, the judges both addressed themselves or directed themselves to that section as being matters they had to consider when deciding whether to make the application.
Might it be fair to describe subsections A and B as two sides of the same coin, in the sense that you have to decide whether the respondent has failed to provide reasonable maintenance, and then you decide what order to make? It would be unlikely that the court would make anything other than what the court considers to be reasonable maintenance. The court isn't going to award unreasonable maintenance.
No. No. I don't know if a fair way to put it is to refer to the thinking of Lord Justice Thorpe.
But do you want to? Okay, but wait. I don't want to take you out of your course. Is there anything in the rest of? So we were going through section 27.
We've got section 27 there. 27(6) empowers the respondent to make to the applicant such periodic payment of such terms as may be specified in the order. And C, in order the respondent shall pay to the applicant such lump sum as may be so specified. And I would NB the generality of the provision. Of course, it's all in the context of maintenance, but we've long since got past the difficulties of lump sum not being maintenance. And if a court thinks that maintenance should be provided by way of lump sum, this is the very simple subsection that provides the jurisdiction. Well, there are several notes to this particular section, including indeed Mostyn J's decision in this case. The next section, if you're in this bundle, or paragraph 28.
Section 28.
Section 28. Can I just deal with that since it's next up on the
Yes.
screen? Duration. Not taking myself out of order, I hope, but because it's here.
Yes.
Subject to an order made on a grant of a decree of divorce, which is not the case
Sorry,
here.
where are you reading from? Oh, I see.
28.1, but it's
Yes.
28.2 is the important paragraph. I was just going to point to 28.1 that talks about the term to be specified in PP or secured periodic payments order in favour of parties should be on such terms as the court thinks fit. And interestingly, under 1A, after the grant of a divorce or nullity of marriage, the court may direct the party shall not be entitled to apply under section 31 below for the extension of the term specified in the order. This is all getting closer to the section 23 jurisdiction. But 28.2 is important. Where a periodic payments or secure periodic payments order in favour of a party to a marriage is made otherwise than on or after the grant of a decree of divorce or nullity of marriage, so that's where we are. And the marriage in question is subsequently dissolved or annulled, but the order continues in force. The order shall, notwithstanding anything in it, cease to have effect on the remarriage or formation of a civil partnership by that party, except in relation to any arrears due under it on the date of the remarriage or formation of the civil partnership. And that's the section that gives the clearest green light, if you like, to the duration continuing beyond a subsequent divorce.
Yes, I understand why you made that submission. Can you just help me on this? If that's the footing for the conclusion that the order can extend beyond divorce, presumably that would apply regardless of whether the divorce was in this jurisdiction or another jurisdiction.
Lord, yes. Yes, say if it was in this jurisdiction, there's every possibility that the provisions of section 23, 4 and 5 would overtake the section 27 maintenance order.
Well, they might in practice, but we're looking here at the question of jurisdiction.
Yes.
And so if the reasoning is section 28.2 tells you that the order can extend beyond dissolution or annulment of the marriage, then there's nothing here which distinguishes between dissolutions or annulments in England as distinct from elsewhere.
No, there's not. I agree.
Yeah. So that would lead to the conclusion that the court had the power to do it both in a case where there was an English divorce in prospect and in a case where there was, say, a Scottish divorce in prospect.
Well, my lord, that's our submission. Obviously, when the learned trial judge dealt with this, he imported a number of, as it were, previous concepts into his interpretation of that section. He doesn't see that section as being freestanding and meaning what it says. He says that there are caveats to applying that section on the true wording that as it stands.
Anything else in the Act?
I don't think so, my lord. I think we've dealt with those provisions.
So you're now taking us to the authorities.
Please,
Which one first?
H and H. It's at page 54, the authorities bundle.
Tab 1.
Tab,
Yeah, tab 1.
is it 8? I'm great.
The tab 1.
Tab 1.
Yes.
Tab 1. Yep. And this was a Section 27 application. Paragraph 1. The sections of the Act, 27, were recently described in the Supreme Court as moribund. This case has demonstrated that's not necessarily the case. And that's our submission. It's not a section that is commonly used, but there are times when it provides essential relief to an applicant, and this is one such case. Lord, at paragraph 7, the judge sets out what we've just looked at, and we've highlighted here the point that Lord Justice Arnold made, that the respondent has failed, but that the court will look at all the circumstances of the case. Section at the bottom of paragraph 5, I hope your lordship's copies are blue lined. We've indicated the passages that.
Yes.
It's a scheme under the 73 Act. Therefore, I have to regard to all the circumstances, particularly take into account those matters set out in the familiar section 25 checklist. Going through the checklist will help me determine whether the provision that is currently made is reasonable. There's no financial support being given. Paragraph 8 seems to me I should start with a brief assessment of the factors mentioned under sections 25(2). First of all, look at the income, earning capacity, property and other financial resources which each of the parties has or is likely to have in the foreseeable future. He notes that the parties can't petition because they haven't been married for long enough. Paragraph 19, given the known fact that...
Sorry, 19.
19.
Yes.
Given the known fact that Mr. H is providing no financial support to Mrs. H when he's plainly able to do so, the next question is whether Mrs. H has a need it would be reasonable for him to meet, given all the circumstances and all the matters I consider under section 25. In paragraph 23, he comes to his conclusion that there has been a failure to provide reasonable maintenance. Evidence from Mrs. H about her historical earnings is unsatisfactory. It's clear to me she's unlikely to have available to her the resources she had prior to the development of the relationship, left in a disadvantageous position whilst this marriage is untangled. Doing the best I can, allowing for the fact that she'll lose means-tested benefits in the meantime, I attach the level of support at, and he comes to £1,500 a month.
Yes.
The emphasis we put on those passages in our skeleton Lord, the paragraph 4 emphasis, going through the checklist, helped me to determine whether the provision that is currently made is reasonable. And paragraph 23, an order of £1,500 a month, backdated to the date of the application. So a broad discretion. My Lord, the second authority is Mr. Justice Newton's case of M. And you have to scroll down, if you would, to paragraph 40. Father's evidence in relation to money was equally unimpressive. He told me about how he'd changed his Audi car because he didn't like the colour, and how the new Mercedes was apparently much cheaper. The amount of maintenance paid to his wife and daughter has been negligible. I'm completely sure, having regard to the investigations and evidence of his bank statements, lucky them one might say in passing, which was unedifying, that there's been substantial sums of money flowing freely in and out between family and friends.
Mr. Cayford, I'm very sorry, but I'm baffled as to the relevance of this case because the judge tells us in paragraph 2 of page 66 this was a pure fact-finding hearing in a case concerning the two children. Where does he say he's got a section 27 application before him? And that he's giving judgment on the section 27 application?
Paragraph 61.
61.
That you're taking us to.
Right, thank you.
Which is the other highlighted passage and referred to in our skeleton.
Are you taking us to any paragraph between 40 and 61, or do you want us to go to 61?
Lord, straight to 61.
Thank you. Yes.
And it's again all about the here and now and what factors the judge has to look at. Unsatisfactory evidence. Clearly the father has the wherewithal, the family resources to pay maintenance to his wife. Recent bank statements bear no relation to his financial circumstances. The older statements show that monies flow through this and other accounts freely, the family pooling their resources when the mood takes them. In regard to what I heard in the evidence and difficulties about it, the father has a pressing responsibility to support his wife and dependents. I'm entitled to make an order under section 27 of the Matrimonial Causes Act, and I do so. Very modest, I'll order that the sum of £400 shall be paid each month, first payment to be made by 4 p.m. on the 19th of July. And again, the passages we highlight in our skeleton, paragraph 17 of our skeleton, paragraph 40, that he has access to considerably greater sums than the meagre sums shown by the bank statements, and that he has the wherewithal, the family resources, and all of this we say is indicative of the relevance and importance of section 25 as a forward-looking test to apply to applications under section 27, and that it's regressive and frankly unhelpful to look back as the learned judge did, even though it's on the basis, he says, that that it's required to find jurisdiction. There's a case which my learned friends...
Can you just help me on this? Because
yes.
I find this a very difficult case to understand. There's a slight flavour in paragraph 61. The judge was making this order of his own motion. Is that my imagination?
I think there was an application for an order, my lord.
Well, you say that, but I can't find any reference to it. That's what I find so puzzling.
Oh.
Because it was an 8-day hearing which was all about the fact finding.
Yes. I must say that I don't know.
I don't think there's. I agree with my lord. I don't think there's any reference in the judgment to an application having been made. So it's certainly possible that he was making it of his own motion.
It would be consistent with the words he used,
It would.
taking a rather holistic view of the case in front of him. But equally, it's clear that there was a great deal of evidence about money and support and lack of support. So one supposes if paragraph 40 is right, he did an investigation into maintenance being paid, and I suppose it'd be a short hop for the mother applicant to say, well, can we please have some more money as well, please, whilst we're at it? I don't know. But the judge clearly spent some time on analysing the financial position of the parties.
Well, and the father was questioned about financial provision for the mother.
Yeah, very much so.
As it says in paragraph 39. So it was clearly an issue that was addressed during the course of the hearing. The precise context for which is not clear.
Yes, I haven't, yes.
Mr. Cayford, can I ask you this?
Yes.
I understand why you're relying on these cases, in particular because of the Section 25 checklist and what you say is the here and now. I get that completely. But neither of them are addressing the particular point, because it doesn't look as if the point was even taken, that there's a difference between the evidence as at the date of the application and anything that might happen subsequently.
Agreed.
I have assumed that that is because this point only emerged effectively in this case, which is why it's this case that's the footnote in the family law practice from which we have, family court practice, from which we have the statute.
Right.
This case is authority for that proposition,
Yes.
rather suggesting to me that that's because this is the first time that's been said in these terms.
That's certainly
Is that
the
fair?
impression the judge had. And he said he'd done some research and couldn't find any authority.
Well, on your earlier submissions, in any event, we're only interested in in authorities post 78.
Well, that's our submission, yes.
Yes, I understand that. So whilst these are helpful in relation to the Section 25 checklist point, speaking for myself, I don't think they go to the more basic question as to whether, when you look at Section 27, what is it that you're looking at? You rely on it in support of your submission, that you look at everything and you don't, as it were, artificially limit it.
Lord, yes, absolutely. I wouldn't want to finish the morning on a bad note for our case, but it's possibly a convenient moment to refer to Learned Friend's new case sent to us yesterday,
Right.
called West, where, despite the best efforts of Mr. Justice Mostyn, it appears he hadn't found it, and we certainly hadn't found it, and congratulations to those on Learned Friend's site who did find it. But it is a case that arguably could be said to provide some succour to the argument of my learned friend. I don't know if your lordships have had any chance to read this one.
No. Do you want us? What do you want us to do?
Goodness me, the head note makes alarming reading.
Yes.
I appreciate it's 1954 and it's now 2021, and I do not regard myself as the last bastion of political correctness, but it's a bit shocking.
Lord, it's very shocking, and it's why ultimately our submission is that you simply ignore this case, because this is the wrong side of history, to coin a phrase.
But in any event, are there any particular passages you would like to draw our attention to? I'm sure Mr. Horton will, but any passages in the judgment?
Well,
or do you want a submission based on effectively what the head note says?
Well, a submission, yes, based on the heading and based on what Lord Justice, as he then was, Denning, says very succinctly at the bottom, which is probably the high point of learned friend's case. In order to succeed, the wife had to show that before the issue of the summons, her husband had been guilty of willful neglect to provide reasonable maintenance for her. Her husband, however, proved that at all material times before the summons, he had reasonable ground for believing her to have been guilty of adultery. That meant he wasn't then bound to maintain her and was therefore not guilty of willful neglect. And on that basis, the appeal is allowed, which, as Lordship says, is a pretty shocking state of affairs. It would seem that if a husband had cause to think that his wife was committing adultery, his obligation to maintain was suspended or effectively null and void, pending the resolution of that decision. And it took until the hearing, when it was found that she hadn't committed adultery, before any obligation to maintain became relevant or appropriate. But his suspicion at the time was sufficient to negate his obligation to maintain, and gave him a defence that it wasn't willful. He had a reasonable belief in the truth of his, or the course of his action, namely that he wasn't obliged to pay her maintenance.
Yes, well, the underlying reasoning is obviously surprising in this day and age. But as I understand it, you accept that, legally speaking, the crux of the decision was that the cause of action had to be established as at the date of the issue of the summons.
Well, my lord, that's what one reads from the text, yes.
And so, to that extent, it is support for Mr. Justice Mostyn.
My lord, yes.
And your main answer to it is to say this is legal, no longer of legal relevance because of the amendments in 1978 in particular.
Yes, Lord, precisely. And that it would be a sad day if the decisions of this court were based on the jurisprudence of the 1950 Act, actually.
Yes, and it's quite, I think it's quite complicated because if one looks at the Master of the Rolls' judgment at the bottom of page 446, that was referring to another case. It's what is the effect of the findings made by the court at the hearing.
Yes. Yes. Applied retrospectively.
Right.
Lord,
Yes. So is that a convenient moment?
It's a very convenient moment, yes. Lord, I might just take you to the section itself after lunch, if I can do that.
Okay. So, how are we doing in respect of time?
Well, my lord, I'm on the last lap in the sense that I'm just dealing with the points we've made in our skeleton. We took 4 points, and we had some introductory observations before that.
So I'm not, without holding you to it, how much longer do you think you might be?
Well, can I hope I'm completely finished within the hour?
Right. Mr. Horton, how long do you think your submissions will take? Again, not holding you to it.
My lord, I've got much to say about what I've called grounds 1 and 3. I don't know how long I'm going to be on grounds 2 and 4 because at the moment I'm still working out to what extent my learned friends relying on them as I understood them to be. But I will let your lordships know about that. I think more than an hour.
Right, okay, that's fine. Thank you. Right, so we'll stop now and start again at 2 o'clock.
Right.